For this lecture, we will discuss the contract of loan. Article 1933 of the Civil Code provides, by the contract of loan, one of the parties delivers to another either something not consumable, so that the latter may use the same for a certain time and return it, in which case the contract is called a commodatum, or money or other consumable thing, upon the condition that same amount of the same kind and quality shall be paid, in which case the contract is simply a loan or mutuum. Article 1933 defines two contracts of loans, a contract of commodatum and a simple loan or mutuum. What are the differences between a commodatum and a mutuum? They are as follows. In a contract of commodatum, this refers to non-consumable things, while in mutuum, it refers to fungible things or money or other consumable. Commodatum is essentially gratuitous. Simple loan may be gratuitous or for remuneration or onerous. It is onerous if there is a stipulation to pay interest. In commodatum, the ownership of the thing is not transferred to the borrower, such that the lender continues to bear the risk because he remains the owner. While in mutuum or simple loan, ownership is transferred and consequently the borrower bears the risk of loss of the thing because he becomes the owner. Commodatum is a loan for use. Simple loan is a loan for consumption. In commodatum, the bailee returns to the bailor the identical thing that was loaned, while in mutuum, what is returned is a different thing but of an equal amount of the same kind and quality. How is a contract of loan perfected? Whether it is a commodatum or simple loan, they are perfected only by delivery. Commodatum or simple loan are not consensual contracts. They are not perfected by mere consent of the parties. Their nature is that of a real contract and is not perfected until delivery of the object thereof. Its delivery is a condition sine qua non for the existence of the contract of loan. However, an accepted promise to deliver may be binding upon the parties and may give rise to an action for specific performance, but until performed, it does not constitute a commodatum or a simple loan. This is what is referred to under Article 1934, which states, an accepted promise to deliver something by way of commodatum or simple loan is binding upon the parties, but the commodatum or simple loan itself shall not be perfected until the delivery of the object of the contract. The accepted promise becomes a consensual contract. Its non-fulfillment will give rise to an action for damages, but it does not yet constitute the real contract of loan, which requires the delivery of the thing for its perfection and which gives rise to obligations only on the part of the borrower. With respect to a commodatum, Article 1935 states, the bailee in commodatum acquires the use of the thing loaned, but not its fruits. If any compensation is to be paid by him who acquires the use, the contract ceases to be a commodatum. Commodatum should be distinguished from the contract of deposit, the contract of lease, and the contract of usufruct. The principal purpose of a contract of deposit is the safekeeping of the thing deposited, while in commodatum, the principal purpose is the gratuitous use of the thing by the borrower. In lease, or as distinguished from lease, commodatum is essentially gratuitous, while lease is always for a price. In commodatum, the bailee acquires a mere use of the thing, but acquires no rights over the fruits thereof in the absence of stipulation to that effect. While in usufruct, the usufructuary acquires a right over the fruits. Usufruct is a real right, while commodatum is merely a personal right. Under the law, the bailee does not acquire title to the thing loaned in commodatum, but only its use, not even to its fruits, unless so stipulated. And for the use of the thing, he is not under obligation to pay the bailor. If he does pay, the contract ceases to be commodatum. It becomes something else, such as a contract for hire or lease of things. Commodatum, or gratuitous loan for use, is where goods or chattels are loaned gratis to be used by the bailee, and then to be resorted to in specie. In effect, commodatum is a form of bailment for the bailee's sole benefit. Commodatum should also be distinguished from usufruct, and the distinctions are as follows. Usufruct is constituted by law, by contract, by testamentary succession, or by prescription. Commodatum, on the other hand, is created by the parties. Usufruct creates a real right to the fruits of another's property, while commodatum creates only a purely personal right to use another's property and requires a stipulation to enable the bailee to make use of the fruits. Article 1939 and Article 1940 of the Civil Code. Usufruct may be onerous, while commodatum is always or essentially gratuitous. The contract constituting usufruct is consensual, while commodatum is a real contract perfected only by the delivery of the subject matter thereof. However, both involve the enjoyment by person of the property of another. They differ only as to the extent and the scope of such enjoyment, jus fruende in one and jus utendi in the other. Both contracts may have as subject matter either immovable or movable property, and both may be constituted over consumable goods. A consumable thing may be the subject matter of an abnormal usufruct, but in a normal usufruct, the subject matter may be used only for exhibition. A commodatum of a consumable thing may be only for the purpose of exhibiting and not consuming it. After the delivery of the thing by the bailor to the bailee, nothing is left to be done by the bailor. It is the bailee who incurs certain obligations, which shows the unilateral character of this kind of contract. And while the bailee enjoys the use of the thing during the time expressly or impliedly agreed upon by the parties, he is under obligation to return the thing upon the termination of his right to use the thing. Compared to a contract called precarium, in commodatum the return of the thing depends upon the termination of the right to use. In precarium, it depends solely upon the will of the bailor, who may demand the return of the thing at any time, regardless of whether the bailee has made use of it or not. Article 1936 states, consumable goods may be the subject of commodatum if the purpose of the contract is not the consumption of the object, as when it is merely for exhibition. As a rule, the subject matter of commodatum should be non-consumable, because the very thing that was loaned must be returned after its use. Yet, consumable goods may also be the subject of commodatum where the purpose of the contract is something other than consumption, such as for exhibition or for display. 1937 provides what can be the object of a contract of commodatum, and it states, movable or immovable property may be the object of commodatum. Article 1938. The bailer in commodatum need not be the owner of the thing loaned. While in the case of simple loan or mutuum, the person making the delivery need be the owner or at least one duly authorized to dispose. But in commodatum, it is not essential. A lessee or a usufructuary may give the thing in commodatum, because commodatum merely transfers the use and not the ownership of the thing. The lessee, by a contract of sublease, may transfer to another the enjoyment of the thing leased for a consideration. So there is no reason why he cannot cede gratuitously its use to the borrower. 1939. Commodatum is purely personal in character. Consequently, 1. The death of either the bailer or the bailee extinguishes the contract. 2. The bailee can neither lend nor lease the object of the contract to a third person. However, the members of the bailee's household may make use of the thing loaned unless there is a stipulation to the contrary, or unless the nature of the thing forbids such use. This provision speaks about the personal nature of commodatum. A contract of commodatum is extinguished by the death of either the bailer or the bailee for the reason that this contract is purely personal in character. The right of either party is not transmitted upon the death of either party. The death of either the bailer or the bailee extinguishes the contract of commodatum. Article 1940. A stipulation that the bailee may make use of the fruits of the thing loaned is valid. Under Article 1935, it prohibits the bailee to use the fruits of the thing loaned. That prohibition, however, is not absolute, but only relative. Under Article 1940, by stipulation, the contract of commodatum may permit the bailee to make use of the fruits. This, however, cannot be presumed because the law provides that there must be an express stipulation. What are the obligations of the bailee in a contract of commodatum? 1941. The bailee is obliged to pay for the ordinary expenses for the use and preservation of the thing loaned. The nature of a contract of commodatum implies confidence and trust, such that the bailee is expected to exercise due care and diligence in protecting and keeping safely the thing subject of the commodatum. The bailee is thus bound to preserve the thing subject of the commodatum and the ordinary expenses for the use thereof, which expense is borne by the bailee. Article 1942. The bailee is liable for the loss of the thing, even if it should be through a fortuitous event, under the following instances. 1. If he devotes the thing to any purpose different from that for which it has been loaned. 2. If he keeps it longer than the period stipulated, or after the accomplishment of the use for which the commodatum has been constituted. 3. If the thing loaned has been delivered with appraisal of its value, unless there is a stipulation exempting the bailee from responsibility in case of a fortuitous event. 4. If he lends or leases the thing to a third person who is not a member of his household. And 5. If, being able to save either the thing borrowed or his own thing, he chooses to save the latter. These are instances of the liability of the bailee in case of loss. Generally, the bailee should be held liable for the loss of the thing, except when it was due to a fortuitous event. However, under the following instances enumerated under Article 1942, the bailee is responsible for the loss even if the same was caused by a fortuitous event, such as when the bailee is guilty of misuse, when he keeps the property beyond the period agreed upon, if there was a previous appraisal of the thing loaned, or when the thing lost was used by third persons, and lastly, if the bailee saves his property instead of the thing loaned. Article 1943. The bailee does not answer for the deterioration of the thing loaned due only to the use thereof and without his fault. This means that the borrower is not liable for deterioration caused by the diligent use of the thing or by its own nature or inherent defect. But he will be liable if he uses the thing in a manner different from that intended or beyond the period stipulated, or when there is negligence on his part. Article 1944. The bailee cannot retain the thing loaned on the ground that the bailor owes him something, even though it may be by reason of expenses. However, the bailee has a right of retention for damages mentioned in Article 1951. The bailor who, knowing the flaws of the thing loaned, does not advise the bailee of the same, shall be liable to the latter for the damage which he may suffer by reason thereof. Article 1951. While the bailee has the right to retain the thing loaned to satisfy damages, such as those in Article 1951, his right extends no further than its retention until payment of the sum for which it is chargeable. The bailee cannot lawfully sell the property for his reimbursement of the damages he has suffered. The mere failure of the bailee to return the subject matter of commodatum to the bailor does not mean adverse possession of the borrower. Article 1945. When there are two or more bailies to whom a thing is loaned in the same contract, they are liable solidarily. So this states the liability of two or more bailies is solidary. What are the obligations of the bailor? 1946. The bailor cannot demand the return of the thing loaned till after the expiration of the period stipulated, or after the accomplishment of the use for which the commodatum has been constituted. However, if in the meantime he should have urgent need of the thing, he may demand its return or temporary use. In case of temporary use by the bailor, the contract of commodatum is suspended while the thing is in the possession of the bailor. While the contract of commodatum subsists, the bailor cannot demand the return of the thing loaned. However, in a special case, as where the bailor has an urgent need to use it, the return may be demanded by the bailor, in which case the contract of commodatum is deemed suspended while the thing is in the possession of the bailor. Under ordinary circumstances, it is a matter of right for the bailee to withhold the thing loaned until the expiration of the period agreed, or after the accomplishment of the use for which commodatum has been constituted. In the absence of an agreement as to the time when the article should be returned, the same may be demanded at will. Under Article 1947, it provides that the bailor may demand the thing at will, and the contractual relation is called a precarium in the following cases. 1. If neither the duration of the contract nor the use to which the thing loaned should be devoted has been stipulated. Or 2. If the use of the thing is merely tolerated by the owner. This refers to precarium, while commodatum refers to a species of bailment by which one of the parties binds himself to return to the other certain personal chattels, which the latter delivers to him to be used by him without reward. Precarium, on the other hand, refers to a contract by which the owner of the thing, at the request of another person, gives him a thing to use as long as the owner shall please. Precarium is a kind of commodatum in which the borrower is bound to return the thing upon the lender's demand. The contract is precarium even if the use or period is not stipulated, if there is a custom with respect to such use or period. 1948. The bailior may demand the immediate return of the thing if the bailee commits any act of ingratitude specified in Article 765 of the Civil Code. Article 765 provides the grounds for ingratitude. 1. If the bailee should commit some offense against the person, honor, or property of the bailior or his wife or children under his parental authority. In relation to Commodatum, if the bailee imputes to the bailior any criminal offense or any act involving moral turpitude, even though he should prove it unless the crime or the act has been committed against the bailee himself, his wife, his children under his authority. And 3. If the bailee refuses the bailior's support when the bailee is legally or morally bound to give support to the bailior. Article 1949 refers to extraordinary expenses in connection with the preservation of the thing loaned. It states, the bailior shall refund the extraordinary expenses during the contract for the preservation of the thing loaned, provided the bailee brings the same to the knowledge of the bailior before incurring them, except when they are so urgent that the reply to the notification cannot be awaited without danger. If the extraordinary expenses arise on the occasion of the actual use of the thing by the bailee, even though he acted without fault, they shall be borne equally by both the bailior and the bailee, unless there's a stipulation to the contrary. The law fixes differently responsibility for the extraordinary expenses incurred. If it is incurred for the preservation of the thing loaned, the liability falls upon the bailior exclusively. If by reason of the actual use, the bailior and the bailee becomes liable, share and share alike. Expenses for preservation are ordinary and shall be borne by the bailee because it is incumbent upon the bailee to preserve the thing. Extraordinary expenses borne by the bailior under the rule that the thing perishes for its owner. The bailee must, however, notify the bailior unless it is so urgent that the bailee must take the necessary measures to meet the exigency. Article 1950 refers to other unrecoverable expenses of the bailee. If for the purpose of making use of the thing the bailee incurs expenses other than those referred to in Articles 1941 and Article 1949, he is not entitled to reimbursement. Unrecoverable expenses include those for ostentation, as well as ordinary repairs and other items for expenditures incurred as a matter of course in connection with the use and the preservation of the thing. Article 1951 refers to the bailior's liability for damages. The bailior who, knowing the flaws of the thing loaned, does not advise the bailee of the same, shall be liable to the latter for the damages which he may suffer by reason thereof. The bailior is liable for the damages because there is bad faith on the part of the bailior under this instance, as when he loans something with knowledge of the existence of some flaws unknown to the bailee, which renders the bailior liable for consequential damages. Finally, Article 1952 provides the bailior cannot exempt himself from the payment of expenses or damages by abandoning the thing to the bailee. The bailior's liability is not extinguished by abandonment of the thing. Abandonment of the thing on the part of the bailior is not bad per se, so long as it will not prejudice the bailee. But when this is done in order to evade a responsibility, Article 1952 prohibits the same.